Okay, I think we'll begin now. This webinar is originating from the City of Vancouver, which is founded on the traditional and unceded territories of the Musqueam, Squamish, and Tsleil-Waututh First Nations. Some speakers will also be presenting from other locations today, and we respectfully acknowledge those traditional territories. Hello, my name is Sophie King. I'm the Manager of Professional Learning at PIBC, and today I have a helper in the background, Ray from our office. So thank you, Ray, for logging people in. I'm very happy to welcome you to PIBC's 5th Peer Learning Network, Ask a Lawyer. Our program today features Alison Espetveidt with Lidstone and Company, Pam Jefcoat and Michael Moll with Civic Legal, and Guy Patterson with Young Anderson. This webinar is being recorded, and a link will be, we will be posting a link to both the recording and the slide presentation on our website in the PLN section of our website. So you can go back and review the presentation. As well, after all the speakers are done presenting, we will be moving on to a Q&A portion of our program, answering the questions that were pre-submitted by you earlier. And because we have so many questions, we will not be accepting any more questions in the chat window today. Through the Peer Learning Network, PIBC continues to engage regularly with the Ministry of Housing and the Ministry of Municipal Affairs staff. The ministry is currently working on new comprehensive guidance documents about proactive planning, and PIBC will be sharing more information about the release schedule as soon as we learn more from the ministry. So stay tuned for that. Through the Peer Learning Network, or PLN as we normally call it, PIBC is also undertaking case study research to provide peer-to-peer information about the implementation of provincial housing legislation. For more information about how you can contribute your expertise and your experience, please see the PIBC e-newsletter that was sent out, I do believe, about 2 days ago, or please log on to the PLN section of the PIBC website. So finally, PIBC has already scheduled the next 2 PLN webinars, which are noted on the first page. I'll go back to it. So on February 26th, we have a PLN webinar on proactive planning for housing and infrastructure in small and medium-sized communities. And the April PLN webinar, number 7, is about the development economics of housing. So lots on the go. And with that, we will move on to our first speaker. I see Michael and Alison already have their cameras on. Actually, yes, Guy will be speaking first. So Michael and Alison, you can take a short break. So Guy Patterson will be reviewing the OCP and zoning bylaw update requirements. Good morning, Guy. Welcome.
Hi, Sophie. Thanks for having me.
Absolutely. And here's your presentation.
Okay.
Turn my camera off.
Thanks. Great. Okay. Here we go. So I can. Perfect. Okay. Hi, everyone. Thanks for tuning in. Sophie said that it's being recorded, so you can go back and watch it or listen again. But I think you should get credit just for watching it even once. I think you should get credit for sticking through us the first time through. My topic, as Sophie mentioned, is OCP and zoning update requirements that local governments are basically being told to get on with, sort of starting now. And I thought that from a maybe big picture kind of overall observation, I couldn't help but noticing that we've got this coffee mug in our office that maybe you can see it. It's from the District of Oak Bay, And you might know that Oak Bay was one of the communities that got a housing target order under the Housing Supply Act. And I think a lot of what I'm going to talk about as far as zoning and OCP updates that everyone is obliged to do has kind of a similar flavor to the slightly kind of more targeted and aggressive approach that the provincial government took with the Housing Supply Act. But a lot of what is being required here reminds me of, the expression, if you build it, they will come. I think what we have here is, if you permit it, they will build it. And therefore you should permit it. And that's another way of saying you should do this proactive planning. That term that keeps being tossed around. And I always thought that proactive planning is just planning, but anyway, to the extent that previous efforts by local governments weren't proactive enough, those are the new marching orders. So what are those marching orders? Well, I wanted an excuse to not go through the legislation in the numerical order that it appears. So I'll start with section 585 on housing needs reports, because really these housing needs reports have become the core of the marching orders of the proactive planning requirements in the new world of official community planning and zoning bylaw drafting, because it all sort of starts, at least most of the new obligations, the ones that I'm going to talk about, start with the requirement to do a housing needs report, and to do it in accordance with some fairly specific instructions set out and prescribed by regulation. And among other things, the instructions are that the housing needs report must include the total number of housing units required to meet anticipated needs for the next 5 years and the next 20 years, and especially that sub 585.3C2 total number of units to meet anticipated needs for 20 years. That's really the kind of cornerstone of all the new, or most of the new obligations. But you can't meet your obligations for OCP and zoning if you haven't done the housing needs report in accordance with the methodology. So again, I thought I'd mention that first. It includes the option of doing an interim housing needs report, which I think has already basically been done. But eventually, the interim reports have to be replaced by a non-interim report. But in any event, what's important, I think, to remember is that the report has to include these total number of housing units required to meet anticipated needs for the next 5 and importantly, the next 20 years. And so in case you were worried about how much work it might be to do a housing needs report, and you didn't want to just hire a consultant, luckily you can go online to the HART website, which I visited recently, and actually fairly easily just plug in your community, and out will pop before your very eyes, like magic, the total number of housing units needed for your community or area in the next 5 and 20 years. That's, I think, what this housing assessment resource tool is all about, among other things. I mean, this website obviously is very sophisticated, does lots of things, but the key thing it seems to do, at least as regards compliance with section 585 and the obligations that flow from that, is to basically provide a very straightforward response to the question of how total housing units do we need in the next 5 and 20 years. I did notice that what seems to pop out is actually a number that says it's called new units. But as far as I can tell, what's really important here is total number of housing units required, and I would have thought that meant total number of housing units in the community in question, and which may include new units, but may also presumably include existing housing units that have already been built over the last 5, 20, or 120 years. But anyway, so total number of units required. I think it's just important to highlight that, because again, using the resource tool, at least in the few minutes I spent with it, at least at first glance, it pops out a number that talks about new units, which again, to me is arguably different than what the legislation focuses on, which is total number of units. So anyway, once you have your total number of units, then you can kind of move on to the next steps in the process, the OCP and zoning steps, which is what I was asked to talk about. And so we can't help it starting with 473.1, which has been in the Act long before any of this proactive planning stuff became fashionable. And it used to say anticipated residential development, for 5 years of housing, and now it's been shifted into a 20-year time horizon, right? So the starting point is any OCP must include statements and map designations for the area covered by the plan respecting approximate location, amount, and type of residential development to meet anticipated housing needs for 20 years. So that's a minor but significant change to the existing wording of the OCP language. And remember that 473.1, there's a lot more to it when you do an OCP, right? Housing needs isn't the only thing in an OCP, but as regards proactive planning for housing, that's the big change. 5 years now says 20 years. And you also have to include housing policies respecting affordable rental and special needs housing. And a new thing, a new obligation is to consider applicable guidelines that have been or will be introduced. For example, in those provincial policy manuals that probably most of you have seen for transit-oriented areas and other guidelines generally. So again, that's just an obligation to turn your mind, and by turn your mind, I mean for your elected officials, whether council or regional board, to turn their minds to these provincial policies when developing your own OCP housing policies. So again, just some minor new content in the Local Government Act to be mindful of and document your compliance with when developing or amending your OCP. Okay, so I know this is way too much text for one slide, but you can easily find this in the Local Government Act, which you'll be consulting on a regular basis, I'm sure. But 473.1 is really, I think, kind of the big event for local government's new official community planning obligations as it relates to housing needs, because this is the link between that housing needs report, which I showed at the beginning, and the official community plan that you're going to be adopting or amending, right? So not only do you have to have the more general thing about statements and map designations, blah, 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 and 473.1, which I won't read to again, but you also have to get around to being a bit more specific in 473.1 sub 3 must provide for, like, the statements and map designations that are referred to above must provide for at least a 20-year total number. And again, I think it's important to remember we're talking about the total number of housing units required. So your housing needs report has to tell you what that total number is. Maybe it just got spat out from the tool, or you hired a consultant, or you came up with it on your own initiative, but you got that 20-year number. And now you have to find a way to include statements and map designations in your OCP that provide for at least that 20-year total, being what's required to meet anticipated housing needs. So that's really, I think, the kind of key new proactive planning aspect of the official community plan that most local governments are going to be obliged to adopt. And that OCP and the obligation to put that content in your OCP has to be done within the prescribed, this is under sub 5, within the prescribed period after December 31st of the year in which council received. So not long after the housing needs report is received, then the council has to make sure that the OCP includes provisions to accommodate the number of units identified in the report as being required. So the report tells you how many units you'll need, and then the OCP tells us where they're going to go, I guess is maybe one way to describe it. So that's as far as I think I wanted to, I think everything I wanted to say about the OCP. And then, of course, the next step, and again, this is kind of like a fairly radical new intervention and new marching orders for local governments who previously could pretty much say whatever they wanted in their zoning bylaws. And usually what they wanted to say was, you can't build anything until you come and negotiate with us. But no more will you be allowed to do that. I guess that's the reactive planning approach that we're getting away from in the new era of proactive planning. So not only do you have to make room for the total 20-year total housing supply in the official community plan, but you also in your zoning bylaw have to permit use and density necessary to accommodate that same number, the total number of housing units to meet the anticipated 20-year requirements. And again, it has to be not long after. I don't have the prescribed period in front of me. I apologize for that, but it's going to be, you can't just not get around to meeting this obligation. You have to meet the obligation once you get the housing needs report that includes the magic number, the 20-year total. Then you have to update your OCP and your zoning bylaw accordingly. So I think that's, and hopefully in a nutshell, what the province means when they say proactive planning. They mean do a housing needs report, figure out the total number of housing units necessary to meet 20 years of demand, 20 years of anticipated need, make room for those housing units in your official community plan, and as well in your zoning bylaw. And again, if you zone for it, they will build it. I think that's kind of the theory. So thanks again for having me. That's all I think I wanted to say, and we'll look forward to hearing from the others, and I guess trying to address some of the many questions that were sent in advance.
Great. Thank you, Guy. We will see you again during the Q&A shortly. And I just wanted to remind everybody that I said this at the beginning of the webinar. We will not be taking any more questions in the chat window due to the fact that we received so many earlier at the time of registration, and we're going to concentrate on those questions right now. So I am happy to invite Alison Espetveidt, our second speaker, who will review inclusionary zoning and density authorities and requirements. Alison, hello.
Hello. I am just
Welcome.
going to.
Here's your presentation right here.
Thanks.
I just need to, okay. There you go.
Excellent. Thank you very much. So, as Sophie mentioned, I'm talking about density bonuses and inclusionary zoning. So we were asked to keep our presentations to about 10 minutes, primarily so that we can answer a bunch of the questions that directly assist you guys in moving forward with some of the new legislative requirements. So this is going to be like not just a bird's eye view of the legislation, but like an airplane level view. So I thought we'd do a quick 2-minute introduction, talk a little bit about a work plan if you're interested in inclusionary zoning or density bonusing, which hopefully you'll understand the difference between the two after the introduction. Just a few really quick takeaways, and then I thought I would do a quick wrap up of some of the things that might be coming in the future. So the introduction here is primarily about understanding the topic. And so under our existing, well, I guess not existing, but prior to April of 2024, there was the opportunity for local governments to use density bonusing and housing agreements to achieve some form of affordable housing in their community. As a result of Bill 16, there's now this additional what's called inclusionary zoning in all of the material, but not called inclusionary zoning in the amendments to the legislation. And they've continued to provide authority for density bonusing. And of course, the housing agreements are stitched in and quite integrated with both inclusionary zoning and the density bonusing. So as I've mentioned here on the slide, the legislative vocabulary is going to be important as you work your way through all of the different legislative rules. So there is a reference throughout the new statutory provisions to a conditional density rule and density benefits zoning bylaws, which are not what's used in any of the sort of layperson material. I talk about the interim guidance quite a bit for unknown reasons. The interpretive aids, so that interim guidance documents, the web pages published by the province of BC, they all use the more common terminology of density bonuses and inclusionary zoning. So that this is up here for you if you're trying to find the provisions in the legislation. You're going to want to be looking for these defined terms. So affordable and special needs housing zoning bylaw is your inclusionary zoning. And basically all of the rules related to that form of zoning is going to be in section 482 with a sort of subsection to it. So obviously the definition references a particular provision, but all of the sections in and around there are going to talk about your inclusionary zoning. The conditional density rule, when that phrase is used in the legislation, it's a reference to the density benefits zoning bylaws, or this density bonusing, which pre-existed the amendments and continues to be in its old section 482 with no sort of points behind it. And then the cross references when it talks about transit oriented development, when it talks about what you can and can't do with these sort of zoning powers, it tends to use the language of conditional density rules to talk about density bonusing. The key differences between the two things is inclusionary zoning is mandatory, and I mean for people who are looking to build things. So if you have an inclusionary zoning bylaw, the affordable and special needs housing units must be built in accordance with the bylaw, whereas density bonusing zoning depends on the density that the proponent, developer, owner, or some combination of those two things might be looking to build to. So you will have a base density, and if they want that bonus density, then they may have to provide a number of different things in order to qualify for the higher levels of density. Under the provisions of the Local Government Act, in order to implement either type of zoning, there is a new obligation, at least in the context of density bonusing, for there to be consultation and feasibility studies that are prepared. But to sort of tie it in with Guy's presentation, it's only the inclusionary zoning that has to consider and will count towards the attainment of the housing units that are required in the housing needs report. So, depending on your community and how you want to achieve those housing numbers, it could be that inclusionary zoning is going to be better for you. One, because you may not have market demand, and also you may want to count some of those housing units towards fulfilling your housing needs report. The other thing that's important, though, to note is that inclusionary zoning is only for the provision of affordable and special needs housing units, whereas your density bonus zoning can make provision for the conservation or provision of amenities, which, at least for the purposes of this division of the Local Government Act, is not defined. And it can also make provisions for the same affordable and special needs housing units. So quickly, in terms of a work plan, the province on their materials and woven into the legislation and various regulations has indicated that sometime in this first quarter of 2025, they're going to be publishing a comprehensive provincial guidance document. So you'll see, I keep referencing the interim guidance document. There may be some additional clarifications. So if you are pursuing inclusionary or density bonus zoning, you'll want to make sure that you are using the most recent and fulsome interpretive aid published by the province. And then the other timeline to sort of pay attention to is by June 30th of 2025, or a later date that may be published in a regulation. Any community that has an existing density bonus zoning in its zoning bylaw has to comply with the new legislative requirements. And those are primarily some of the things that is woven throughout this presentation. That's the consultation and financial feasibility studies. So the interim guidance has put together sort of a work plan for everyone. It proposes that you should create your bylaw, you should then consider your housing needs report, then embark on consultation, then embark on your financial feasibility analysis, do some steps towards the alternative compliance options, which I'll talk about later, and then finally adopt your bylaw. I have suggested that process maybe doesn't make the most amount of sense. As Guy mentioned, the housing needs report is really the linchpin of a lot of what is happening with proactive zoning. And so to me, it made a lot more sense to make sure that you have your housing needs report sort of pinned down, or at least a framework for it, some understanding of what may be missing. There's also an opportunity in the Local Government Act for the local government to set the terms of the consultation. That includes both like methods of consultation, but who is going to be identified as a stakeholder for the purposes of consultation. Generally, if you are embarking on this process, I think it would be good for your board or council to, by resolution, identify who is going to be consulted as part of the process. I also would generally suggest it may not be helpful to prepare a bylaw until you've gone out to those stakeholders and asked them, what their concerns are or what approaches they may be interested in pursuing. The financial feasibility study is also a sort of a massive undertaking, and similarly, I don't know how useful it is to have a bylaw prepared if your feasibility study is going to say the costs, for example, of providing affordable housing are maybe too high, or the definition of affordable housing needs to be reined in a particular kind of way. Same with the percentage of units or gross floor area that is going to be required as part of your inclusionary zoning. And you'll see then I've suggested, once you have all that information, once you've synthesized all of the feedback from the consultation, all of the information from the feasibility study, I think you should probably go back out and consult on the draft of the bylaw that exists and then adopt it from that point on. In terms of key takeaways, I think it's obvious to anyone who's on this call that the suitability of these tools in large part is going to depend on local market demands. I think, you know, if you have an expensive market with not a huge demand, Guy mentioned in his presentation, if you zone it, it will be built. That may not necessarily be the case. And certainly, I think there is the possibility that in pursuit of affordable housing, the barriers to sort of viability, and that's language that's talked about a little bit in the interim guidance, might I mean, you're not supposed to adopt any type of inclusionary zoning or density bonusing if the feasibility doesn't support it, but certainly you're going to have to look at what is realistic for your community. In some of the questions that were circulated in advance, some of the questions were, how to do X, Y, or Z. And what I want you to take away from this presentation is the local government itself has a fair amount of flexibility. The legislation is primarily focused on process. And so if you follow the process and do the steps that are involved, there is a degree of individualization that can happen in terms of the different definitions, the types of ownership or form of tenure that these different units need to have, the definition of what's affordable, the amount of time that the units are going to be subject to the conditions. And so you can try and tailor and tinker what you are asking for through inclusionary zoning so that it will work with your local market demands. One of the things that I think is different or grows from the amendments is that there is an express obligation in the legislation for the details of what is required to be embedded in the actual zoning bylaw itself. So some of the questions that we'll maybe address in particular dealt with, how do you continue to negotiate with developers? And the purpose of the amendments to the legislation was to create binding rules, but the um, sort of corollary obligation for those binding rules was that the rules be laid out quite clearly and quite precisely, so that people who are building housing units in your community know what needs to be met. The other thing that I think is worth mentioning is that it's important that the conditional density rules aren't used to undermine the minimum density for SHMU. That's your small scale multi-unit housing, or the transit-oriented areas that are not really the topic of this conversation. And I also quickly want to point out that there are alternative compliance options that allow for payment of cash in lieu or the provision of housing units on a different parcel than the development site. There are exceptions. The exceptions are certain types of housing units that will be owned by certain types of affordable housing unit providers. There was nothing particularly controversial to me about that exception. They're local government housing authorities and the BC housing organizations and those kinds of things. There's also protection for in-stream applications. We'll touch on this a little bit more in the questions, so I'm not going to cover it as part of the presentation, but you'll find that there's protection for both density bonusing and inclusionary zoning, and it references existing definitions for development cost charges. So just quickly, in terms of a wrap up, the expectation is that there's going to be, or at least the possibility of, further regulations. So we'll keep an eye out for those. Probably the biggest and most significant is that by regulation, the province can curtail a local government's inclusionary zoning authority. And there's a whole bunch of things that can be curtailed, including the ability of the province to just straight up prohibit specific local governments from using inclusionary zoning. In terms of additional resources, I guess sort of gold standard of interpretive aids are this interim guidance on inclusionary zoning and density bonusing. It's a relatively accessible document that it sort of explains what the intention of the statutory provisions are. And so to the extent that you're looking for sort of plain language guidance for the legislative language, it's helpful. But as I mentioned, it can sometimes be frustrating to try and apply the guidance to the legislation given the very different language that's used in the two documents. So with that, that's the end of my presentation. I'll hand it over. I think it's to Michael now, right?
Great. Thank you, Alison. Yes, Michael Moll is our next speaker, and he will provide a review of small-scale multi-unit housing, or as Alison called it, SHMU. Some people say SHMA. It's up to you. We don't mind. You can say whatever you like. And the covenant issues. Thank you. Hi, Michael. I will get your presentation going. Here you are.
I say SMU, and I guess maybe I'm in the minority. But anyways, my topic's a bit more discrete, focused issue. I'll admit a few years ago I pitched the enforceability of covenants as a topic I wanted to speak to PIBC, and it wasn't picked. And now it's getting a slightly hotter topic, so be warned, I might pitch it again. What in part drives this is the policy manual, which you all read thoroughly last year, mentions covenants and sets out in very general terms that the existing Section 219 covenants are not affected by SMU legislation, but local governments should not pursue new covenants that would prevent the prescribed residential densities required under the legislation. But covenants can still be requested for health, safety, and the protection of the natural environment. And so this policy direction raised some questions that have been asked and were submitted again today. So I will be just talking about a few of those issues here. But before I do so, I want to just lay out in very simplistic terms sort of the differences between a land use bylaw and a Section 219 covenant. You probably all know this or intuitively know this, and I also have to caution that trying to write it out in 4 words or less, I'm missing out on certain exceptions. So for example, I say 219 covenant applies only to the registered owner. There is historical case law saying that occupier with notice of the covenant can also be enforced against. There's all these little nuances there, but the key difference for the purpose of my talk is that bylaws sort of they endure unless they're repealed or amended or quashed by the court, whereas a covenant can be vulnerable to waiver and obsolescence. So in the case of a bylaw, if you didn't take enforcement action last month, that should not affect your ability to take enforcement action this month. That may not be the case for the covenant. If through time your failure to take enforcement action could cause the court to conclude that you sort of waive the right to enforce that covenant. And then there's also circumstances where the court might say, well, the covenant's obsolete. It's no longer pursuing a goal that the person who obtained the covenant still requires to enforce. So how that plays out in local government context showed up pre-SMU in a case called Natura Developments in Ladysmith. And the premise of this case was quite straightforward, that there was a covenant binding land and it restricted the density to 15 units, but it just so happened through a complicated series of events that if you look at the zoning, the land could be used for 29 units. And the owner, who wasn't the original developer who agreed to the covenant, but the current owner came to the court and said, look, this restriction is obsolete because clearly the council's okay with 29 units. There's no basis for them to restrict us to 15 by covenant. And the court did not accede to that argument. They said, well, the purpose of this covenant is to restrict density. That's something that the covenant can do. And I consider that need to restrict density to still be current, so the covenant survives. And I'm summarizing this case in very simplistic terms, but there the court sort of viewed it as two different instruments that could be targeting the same objective. A council can control density through a covenant, or a council can control density through zoning, and how it chooses to do it doesn't really matter. If one's more restrictive than the other, the more restrictive one will prevail. I'm not that confident that case would be decided the same way now with the SMU legislation and the province's direction. I think there's a stronger case for saying if you rezone and even if you're forced to rezone by legislation, you can't do what the policy manuals tells you not to do and use your covenant powers to try and preserve the historical density requirements. But as it stands, the Ladysmith case is certainly an argument that a current density control under a covenant, 219 covenant, would still be enforceable today. But other questions are raised about, well, what about the private covenants? And it's not just local governments that can restrict density. You can have a restrictive covenant that effectively prevents your neighbor from building to a higher density. And the most common way that this is done, I would say, is through a statutory building scheme, which in short is sort of like a reciprocal restrictive covenant, where everyone's bound by its terms, but everyone can enforce its terms. And the basis of these covenants is really that you don't, I would say, it's not enough to rely on the local government to impose a desired density. As it's shown, even if you feel you can elect people who will vote to limit your neighborhood to single family dwelling, the legislature might send it in a different direction. And it might also not be enough to count on the market to only have people buy your properties who want to keep them single family dwelling. So a sort of a private covenant or a statutory building scheme established at the development stage, that could say everyone here is bound to a scheme, and that scheme is single family dwelling. And on its face, that scheme should still apply despite SMU. There's separate regimes, and just because the council permits it doesn't mean that the owners themselves have to permit it. Notably, for a statutory building scheme, it's enforced by someone who's subject by the scheme. It's not enforced by an outside entity, and so that is the that is a key distinction that you should keep in mind. And the other thing is, and I'll talk about a bit more detail on the next slide, a lot of schemes involve the developer as sort of a regulator who grants permissions and variations and all that, which was usually done to get the project off the ground and deal with slight variations at the beginning, but seem to complicate how they're implemented now, because really, at least in my view, a scheme should just be rules like that apply to everyone, and not sort of administered by an appointed body. But that's just me. So what about statutory schemes and smooth legislation? And for that one, my final slide covers a recent case which made the headlines in the Vancouver Sun, which is a bit of a surprise to me. But there, an owner was subject to a statutory scheme, was selling the land, and part of the issue was that the land, couldn't be developed to a higher density because of the scheme. And so that owner petitioned the court to cancel the scheme for obsolescence. And in the claim, the owner said, Bill 44 and resulting legislative changes have rendered the SBS obsolete. And my view would be, well, someone should be claiming the opposite, like that Bill 44 and the resulting legislations have made the SBS more important than ever, because this is what's preserving the single family density that we all bought into. However, I'm not representing anyone in this particular case, and maybe that's a good thing too. But they made their claim, and notably, no one responded. And that's the other half of the statutory building scheme. One of the owners has to come in and say, no, the scheme must be enforced. It's not obsolete. And no one did. And the petitioner was kind of in a sweet position, because someone had to fight it, would probably be paying a lawyer to argue that this scheme still applies. And if they win, the result is likely to depress the value of their land. So by not fighting it, they are sort of inviting the end of the statutory building scheme and inflating the value of their land. So you really have to want to maintain your single family neighborhood for above all else, and regardless of money, and be able to have the resources to fight it, to sort of defend these schemes. So that kind of suggests in a world where there's a high demand for housing, and density is more valuable than sort of large mansions, that it's really only the biggest properties that might benefit from a statutory building scheme. So in this case, no one fought it. The court never really dealt with the question of whether or not the zoning bylaw should compel a change to a building scheme. But the owner got what they wanted, and that is how that played out in that particular case. However, you ask me, I think there's still plenty of room for people who are currently subject to statutory building schemes to argue, no, we amongst ourselves have agreed to be single family dwelling. SMU legislation doesn't compel the construction of density, so we would like to keep our neighborhood as it is. Notably, I think the province has said they're looking into it, so maybe they would push back on that. But again, that remains to be seen. So I think that's all I want to cover on my presentation. If a question comes up that we don't answer later on, please just give me a call. I'm happy to. I love this stuff, so I'm happy to chat about it.
Thank you, Michael. We'll see you again in a few minutes. And finally, our next speaker, Jefcoat, she will conclude with a review of amenity cost charges, or ACCs, and associated issues. Welcome, Pam. How are you?
I'm great. Thank you so much for having me.
You're very welcome.
Great. Okay. Well, and thanks to the audience for hanging on. This is a lot of material to cover in a very short period of time. But I think, as Alison said, I think the idea today is really just to give you a very high-level overview of what's out there and what's going on, and then as Michael said, please feel free to follow up with questions if they don't get covered today in the session. Okay, so today I'm talking about amenity cost charges, and is one of the bills that was introduced recently, or 2023 now, so not so recently, but was Bill 46, and that was the Housing Statutes Development Financing Amendment Act. That act did more than just introduce the concept of amenity cost charges. It also added provisions to local government authority in respect of DCC collection to broaden the purposes for which DCCs could be collected. And under the revisions, local governments can now collect DCCs for fire protection, police, and solid waste and recycling facilities. So that was sort of one piece of the Bill 46. The other piece was to introduce this new financing tool for local governments that allows them to collect funds for capital costs of certain amenities or for the expansion of existing amenities. So the legislation does give a definition for amenity, but just keep in mind that the definition is inclusive and it's not exclusive, so it may be other things than what's listed. But generally, an amenity is a facility or a feature that provides social, cultural, heritage, recreational, or environmental benefits, including a community, youth, or senior center, rec facility or athletic facility, library, daycare facility, or public square. So it's a fairly broad definition, and which gives you some scope in terms of what you would define as an amenity for the purposes of the bylaw. One thing to keep in mind is the amenities must benefit directly or indirectly the development for which the amenity cost charge is being imposed and the increased population of residents or workers that result from the development. The amenities must also be owned by the local government, but they can also be owned or operated by a third party if they're subject to a partnering agreement with the local government. So there's quite a lot in the legislation about process, and I'm going to refrain, since I only have 10 minutes today, from sort of going through all of the legislative provisions, because you can all read the legislation yourselves. But some of the key pieces are that, like development cost charges, amenity cost charges have to be imposed by bylaw. One of the key differences is that the inspector of municipality approval is not required for the bylaw. The bylaw must specify the one or more ACC areas where the ACCs will apply, as well as the specific projects in the area for which the cost charge will be imposed. And then the amount, like a DCC, the amount is to be set out in the schedules to the bylaw. And the legislation, as I said, does go through quite a lot of detail in terms of the considerations that local governments must consider when setting the charges. And the things that must be considered, like your housing needs reports, estimated growth for the area, the types of amenities that are contemplated to be in your official community plan or your financial plans. And like DCCs as well, the legislation also requires local governments to consider the rates that are being imposed and whether they may discourage affordable housing or are out of line with servicing costs and so on. So those provisions are very similar to when you're setting DCC rates. And a lot of the interim guidance thus far has said that local governments can consider sort of the best practices in the DCC best practices guide, which now is, of course, over 20 years old as well, but when establishing their ACC programs. So there's also a requirement for consultation. So the government must consider one or more opportunities that it considers appropriate to consult with public and affected parties. And again, that goes back to just ensuring that the rates that are being set aren't going to discourage affordable or reasonably priced housing. So that's probably, you're going to be speaking with UDI and other development industries in your area in terms of the impact of the rates on the community. So like DCCs, ACCs are also paid at the time of subdivision or building permit issuance. And the development cost charge installments regulation was also updated to also refer to amenity cost charges. So ACCs can also be paid in installments like DCCs previously could be. And the same provisions with respect to installment payments will apply to amenity cost charges as well. So there are transitional provisions in the legislation to deal with in-stream developments that have applications in at the time that these bylaws are enacted. So there's two sort of scenarios that the legislation contemplates. The first is where local governments are establishing the first ACC bylaw. And in that case, the charges don't apply to a development if the local government has received a complete, referred to in the legislation as a precursor application. So if they've received a complete application for a building permit, development permit, or zoning bylaw, and that's basically the in-stream application means the application hasn't been rejected or withdrawn. And if it's a precursor application, it must have been complete, received by the local government, and fees paid. And in that instance, where a precursor application has been received, the DCC bylaw, or sorry, the ACC bylaw won't apply to that development. Then the second scenario is where there's now an amendment to a DC, or I'm going to keep saying DCCs and ACCs throughout this, but where the amenity cost charge bylaw is already in place and applicants have submitted a complete precursor in-stream application for a building permit, development permit, or zoning amendment bylaw, they're given a 12-month exemption, similar to a DCC exemption. They're given the 12-month exemption from the new rate that is established by the bylaw as long as they receive their building permit within that 12-month period. So that 12-month period runs from the date of adoption of the bylaw. Now, similar to DCCs, an applicant can agree to comply with a new amendment bylaw. So it may be, and maybe the rates are reduced or there's something advantageous. So the prohibition from it applying can be waived by the applicant if the circumstances merit the applicant wanting to pay the new rate. There are also exceptions for which amenity cost charges cannot be or not payable for. So the legislation lists these out in detail, but they include places of public worship, developments that do not result in an increase in population or residents or workers, developments that have already been charged for the amenity, affordable and special needs housing under a zoning bylaw. So that would be the inclusionary housing that Alison was referring to, and classes of affordable housing that are prescribed by the prescribed classes of affordable housing regulation. So for those of you who are familiar with the DCC regime, bullets 2 and 3 are where the bulk of the case law around development cost charges comes in. And of course, amenity cost charges are so new. So we don't have a body of case law yet in terms of how the courts will interpret these, but I suspect that the DCC case law will provide guidance in terms of how the courts interpret these provisions as we move forward over the years. And waivers and reductions. So again, as with DCCs, local governments can by bylaw establish categories of eligible developments for which amenity cost charges can be waived or reduced. And this concept is quite important because under the legislation, local governments are not allowed to assist a business, and assisting a business includes waiving or reducing a fee unless it's statutory authorized. So this is the provisions in the legislation actually authorize you to waive or reduce the fee, but you have to do it by bylaw, and it can only be for an eligible development. So eligible developments include not-for-profit rental housing, including supportive living housing, for-profit affordable rental housing, and housing that's subject to the requirements of affordable or special needs housing zoning bylaw, again, the inclusionary zoning bylaw. Okay, so I'm moving through this quickly so we can get to our questions. There are quite a few of the questions, I think, that were aimed at my topic. I'm going to probably, hopefully, cover with this slide. But of course, there's a number of development financing tools that local governments can use, and amenity cost charges are just a new tool. And so the question arises, how does this impact or affect other tools that local governments are currently using? So with respect to development cost charges, the legislation provides that you can't charge an ACC for a an item that would be covered or could be covered by a development cost charge. So, you know, DCCs are imposed with respect to sewage, water, drainage, park improvements. They can now be imposed with respect to fire protection, police, solid waste, and recycling. So for the matters that fall within the scope of what a DCC can be collected for, you can't collect an ACC for them. For density bonusing, you can still collect, you can still get amenities through the density bonusing regime. The legislation, however, provides for basically the no double charging rule. So effectively, well, if you've charged an ACC for a particular amenity, you can't then use your density bonusing to charge again for the same amenity. And so that kind of is the tenor that runs through the legislation, is you can't make a developer pay twice for the same amenity. So you can still use density bonusing so long as there isn't double payment. Community amenity contributions, I mean, that one's always been an interesting one because it's not statutorily authorized in the first place, but it is a standard common practice. And I think until such time as the court says otherwise, local governments can continue to charge community amenity contributions as part of a voluntary negotiated rezoning process. But again, the same rule would apply, is that you can't collect a community amenity contribution for something that you've identified as a amenity that can be charged with an ACC. So for example, if you've established in your ACC bylaw that a particular community center is an amenity project for which you're going to collect ACCs, you can't then have a contribution towards the same community center be also payable under a CAC. And the same goes with phased development agreements. So, there's nothing in the legislation on this, but the concept is similar, right? If you've negotiated for an amenity under a PDA, you can't then also charge an amenity contribution for it after the fact. And the legislation is quite explicitly says that ACCs are not payable for amenities for which a contribution has already been paid. So there's a number of tools and you can use all of them and interplay with each other. You just have to make sure that you're not charging twice for the same amenity. And I think that's it. I scrambled through that pretty quickly, but it is 1 o'clock and I think that leaves us with a half an hour for questions. So with that, I'll let us go for the question period.
Thank you, Pam. I would like to invite the rest of the speakers to turn on their cameras and microphones. And we will begin. Who are we missing? Alison. There she is. Okay. Hi again, everybody. So I'm going to go through the questions fairly quickly. If you feel that you've already answered them within your presentation, please just say skip and we'll move on. I will invite one person to begin the conversation. After they've answered the question, the other people are more than welcome to jump in if they like. Otherwise, we'll go on. Okay. So we'll do question number 1. Does the in-stream protection for new density bonus bylaws also apply to developments that have a previously approved precursor application, but not a current in-stream application? Alison, would you like to answer that one?
Yeah, and so the answer is yes. Pam did a very effective job at going through what the language in the legislation is with respect to what is an in-stream versus precursor application. And the same rules are carried forward for both bonus density and the inclusionary zoning. So you may have a bit of a transition period if you have a zoning bylaw amendment that has been submitted in a complete form according to your development application procedures bylaw and the fee paid sort of prior to the adoption of your density bonusing bylaw.
Great, thank you. Any others? No? Okay. We'll go on to question 2. Are there any significant changes expected with the most recent bills 16 passed by the provincial government? Pam, would you like to answer that one?
Yeah, I'm not sure if I'll be very thorough in it. I mean, that covers unless I'm missing something, it covers the inclusionary density bonusing tenant relocation bylaws that can be enacted, as well as site level infrastructure and TDM authorities. So there's quite a lot there. I don't know to the extent to which we want to go into all the detail there, but there are a lot of new bylaw authorities, some of which we've talked about today. But yeah, there's much more coming.
Okay. Any other comments? Okay, question 3, what are the requirements for inclusionary zoning? I guess back to Alison for that one.
Yeah, and so I touched on it a little bit in my presentation, but I will take this opportunity just to sort of reiterate the point that I made, which is that the requirements for inclusionary zoning are focused more on process, not on content. And so you're going to end up with lots of different versions of inclusionary zoning, but within the nuances or differences that you might find, I do think it's helpful to think about the definition of what is that zoning authority. And it's the ability to require a portion of a development be affordable and special needs housing units, and that the portion can be decided either on a per unit basis or on a percentage of the gross floor area of the residential component of a development. So, so long as you're meeting one of those sort of 2 criteria, that you're mandating a certain portion be either in the form of units or in the form of gross floor area, you should be very conscientious about making sure that you have followed the process, and that is how you get your inclusionary zoning.
Great. Thank you, Alison. That was quite thorough. We'll skip to number 6. As we look at how to apply Bill 16 to land, we will be pre-zoning. Can you tell us more about how to obtain land dedication from pre-zoned land and what the limitations may be? We'll go to Michael for this question.
Oh, okay. So in short, what you're now will be able to do is to take land at building permit issuance. It could be, and the limitations are that the land can only be for highway or for suitable design features infrastructure set out in the Act. And then there's also currently limits as to how much in terms of depth you can take, and those limits can be further altered by regulations which have not yet been adopted. But an interesting question is, for the highway, I foresee that as being, they have to dedicate the land as highway, but for other uses, I don't know, is it going to be fee simple or some other right over that land? There's lots of questions that are being raised in my mind, but that's my quick answer.
Great, thank you. Any other input? Okay, we'll move ahead. This question is for Guy. Number 7, why is the provincial legislation requiring cities to update their OCPs and zoning bylaws in 2025 through Bill 44 before the province has defined the role of a servicing officer, which would enable cities to carry out new authority under Bill 16? How are cities navigating this to ensure smooth transition to large-scale pre-zoning? Oh, did we lose Guy?
Maybe.
Oh, sorry, Guy. He's not logged on anymore. Maybe he'll come back. Sorry about that. Michael, are you able to answer that question for us?
I don't know the why. I checked this morning to see whether there's the regulation regarding servicing officers has come in and couldn't find it. So I'm quite curious to know when that would be. But,
okay. Ray, if you see Guy logging back on, just leave that alone and I will take care of it. Thank you. Okay, going on. We have a lot of Guy questions.
I was just going to say, he jumped off on purpose. I think
he did. Okay. Let's go to a question for Michael, number 16. So what are some legal challenges potentially arising from insufficient infrastructure servicing to get to building permit for areas zoned for SHMA that do not have the underlying infrastructure capacity?
Okay, so well, the one challenge I would focus on is that many bylaws have a provision saying you could sort of be denied either like a right to connect or right to building permit if the capacity isn't there. And I'm not sure that how well that will hold up given SMU, and the policy documents have been quite clear saying the requirement to move density from 1 unit to 3 or to 6 is no different than if the current single family dwellings all had everyone's extended family move in, and suddenly 3 people are 10, and you're drawing more water, emitting more sewage, and creating more traffic. Just deal with it. So the concern, the big legal challenge would be someone applies, they've got the zoning, they comply with everything, but the municipality says, no, we don't have the water for you. They would just, I say, judicially review that and say, I get as much right to the water as to my neighbor, and if there's a shortfall, you should build more infrastructure using general revenue. And that's kind of the trend I think the province is pushing.
Great, thank you. Guy, can you hear me? Are you able to turn your camera and microphone on? I see you've logged back on. Okay, if you can do it, it would be great.
Okay, can you hear me now?
Yes, we can.
Oh, this is exciting. We had a big power outage in our office, so now I'm back on with my
Oh.
laptop and my cell phone hotspot.
Wow, you're very resilient. Good for you.
It's a total fluke that I had those things and that it actually worked. But anyway, thanks. Sorry about
Wonderful.
that. Yeah, just all of a sudden everything just went dark.
All the remaining questions are for you, Guy.
Perfect.
Yeah.
Well, I'll just.
That's
I
what we
heard you,
thought.
Pam, say that I was trying to avoid all the arguments, which is probably true. I couldn't really deny it, but I didn't. So yeah, sorry about that.
Okay.
What question do you want me to take now, Sophie?
No problem. Let's go on to question 10. Has the province prepared
Okay.
regulations or a guidance manual regarding the development and servicing aspects of Bill 16? And you did show us some manual during your presentation. Is that the one?
No, I don't think we have a manual for development servicing aspects, to be honest. Oh yeah, I see it. Okay. As far as I know, I don't know. You know what I will say though, I can't resist mentioning this. Oh, yeah, we don't have, I won't go on to that other tangent, but as far as I know, there's no manual about Bill 16.
Would a manual be helpful?
I don't know. I'm not sure that we need it. I mean, to be honest, in my experience, the manuals just make things more confusing, not more clear. But anyway, my preference is just to read the legislation. And I mean, not for me to read it, but for you to read it. But anyway, yeah, like there's so much of this, like the province is trying to legislate through their manuals. But as far as the Bill 16 changes, it says pretty clearly, you can require extra. I think we're talking about extra road dedications, for example, for transit features and sustainable, green infrastructure. I know that's not the wording of the statute, but anyway, I don't see a lot of need for policy guidance on the Bill 16 changes myself, at least as regards development servicing.
Okay,
yeah,
thank
they
you.
do have some, sorry, I'll jump in. They do have, I think, some guidance around the bylaws for like new tenant relocation bylaws and, around that. I don't think it's an actual manual, but they have produced some guidance document around that, but I haven't seen anything on the servicing side either.
Okay, thank you. The next question is number 4. Without a bylaw enacted under LGA 482, can a municipality still negotiate a portion of affordable housing units as part of a rezoning application? And this one is Alison.
Yeah, so Pam, this sort of, and maybe Pam wants to expand a little bit on what she said in her presentation. She talked about CACs, and I think both of us would agree that the answer is a cautious yes. The legislation has never contemplated CAC negotiations in the first place. So to the extent that that's a practice that exists, it is informal. I just always feel compelled to remind people that there was Supreme Court of Canada case law about the fact that these negotiations have to be voluntary. You can't contract by zoning. And so to the extent you are developing CAC policies or minimum contributions, I think as the legislation has created specific processes, content, and protections for mandatory contributions in the form of ACCs or in the form of inclusionary zoning, the more your CAC process or protocol or program looks like one of those other types of mandatory contributions, you're going to get yourself in trouble.
Yeah, no, I think that I agree with you, Alison. And I think if you look at it from a very big picture in terms of what Guy was talking about too, the intent of these legislative changes is to be proactive and to try to eliminate some of the uncertainty and cost uncertainty for developers as they move forward in constructing these things. So even with the ACC program, I think the intent is to pre-identify so that there's some certainty around the costs and to cost out what those costs for such amenities will be, and to give the development community some advance notice of kind of what the overall cost will be. But again, it's permissive under the legislation to adopt an ACC bylaw. It's not a mandatory requirement. And until a local government adopts the bylaw, I think it doesn't mean you can't collect for amenities. But as Alison said, you need to be cautious in how you do it.
Before we go on, could you all clarify on whose side you represent? Who represent? I know Guy represents municipalities or local government. Alison does too. Michael and Pam, what is your as well?
Local government. Yeah.
Okay.
Yeah.
Great. Our next question from Michael in number 8, in the context of pre-zoning development sites and Bill 16, should municipalities be updating servicing bylaws or other bylaws to make use of these new powers, or simply focusing on the new zoning tools?
In terms of there's new powers, so use them. I'll just say that you can take land for new purposes, so that should compel an update, and you probably want to. But that's a policy question there.
Okay. The next one is number 15 for Alison. Pam, I think your section is in the second set of questions, but feel free to jump in whenever you'd like. So Alison, does the new legislation provide any flexibility for smaller communities with limited development activity to meet housing targets?
Yeah, I mean, the portions, I guess, of the legislation that I covered, so the density bonusing and the inclusionary zoning, those are optional. There's no mandatory obligation to pursue either of those types of things. Guy's presentation focused a little bit more on that housing needs report. I think that might be where some of these smaller communities are going to have to start the work and then figure out that division between, what the development community is sort of willing and interested in building, and then what's missing, and what tools they may want to use to fill in the gaps between what the market might generate of its own accord and interest, and what the housing needs report reveals is part of the community or community needs. But for the most part, I think the challenge is going to be in the base density. Like, the tools that I talked about are very much driven by market demand. And so if as a community you're doing the pre-zoning that all of us have talked about in some way, shape, or form, one of the challenges or flexibility issues you may have as a smaller community is sort of woven into all of the questions that we've had asked, which is if you've pre-zoned for higher density, how do you continue to negotiate for some of the things that your community might need and doesn't have the capacity to necessarily create, you know, complicated amenity contribution bylaws or those kinds of things. And so, you know, if you are a smaller community, you may be looking to continue things like CAC negotiations. Unlike Michael, I do think probably you're going to be looking at your development servicing bylaw to make sure that a practice that you had previously done on a more ad hoc basis is now, you know, you are empowering your development officers to look at you know, minimum servicing requirements and those kinds of things to, I don't know that it's necessarily flexible, but at least you have tools that you can enter into a negotiation with the developer about how you're going to achieve your subdivision and development servicing bylaw requirements in light of their specific development, and maybe there's some room within that process.
Thank you. Any other comments? Okay, moving on to number 20, and this is a question for Michael. Given that the zoning bylaw was required to be updated by a specific date last year to incorporate SHMA regulations, is it now necessary to update the zoning bylaw to align with the OCP by the end of this year? Is it practical to update both OCP and the zoning bylaw together at the same time?
And I might be misunderstanding, because the requirement now is to update the OCP by the end of the year, and there was sort of an exemption granted for the mandated SMU changes. So by the end of the year, the zoning bylaw and the OCP should be consistent. So because the zoning bylaw has to be consistent with the OCP. If both need amendments to get you there, then you should be amending both. But I invite anyone else to comment if they see it differently.
Okay. Sorry, I just, so the next question, number 18 for Guy. Are there specific provincial guidelines or templates for updating OCPs to better align with the current housing needs in the community?
I mean, I think the short answer is not that I'm aware of. You have to identify the total numbers as noted in the housing needs report requirements. And then, I mean, this might be unfair for me to say this, but I've read so many OCPs, and in my view, Section 473 of the Local Government Act is the best template ever created for OCPs, and none of the OCPs I've ever read look anything like Section 473. So start there before you ask for any new templates. That'd be my advice.
Okay, thank you. Question 30 from Michael. Exploring the complexities of strata titling SHMO units, what are some key legal considerations?
Oh, I don't know if I could answer this briefly, but I think it's just, you're going to have to be live to the risk that a SMU development could be stratified. I don't see a straight barrier to that. But then when you're setting your siting standards, the feasibility of that alignment, the use of common property is going to be an issue. But if other people have a comment, I'm curious myself.
Okay, thank you. I'm going to go on to the second part of our questions, which deal with other topics. Just give me 30 seconds. I'll give you a bit of a break. Hopefully this works. Okay, not bad. Let's go on to a question for Pam. Number 42, which is down at the bottom here. I'd be interested in hearing about future use of CACs within the context of the new financial tools. Is that something you can answer briefly, Pam?
Yeah, and I think I already have, really. And that was what Alison and I were both sort of talking about, was I think the ability to use CACs is still there. It's not legislatively authorized, and so there's just caution. The province is clearly pushing local governments to identify and create certainty around these types of costs, and have some transparency around it as well. So I think you can still use the process, but each time we see a push to identify these types of things in bylaws, it opens the door for people to make an argument that the process, this discretionary process outside of what's authorized by legislation, may no longer be appropriate. So, yeah.
Okay, thank you. We'll go to number 43, again for Pam. Does stratification of 4 or 6 dwellings on a small lot trigger park dedication, cash in lieu, or land contributions?
Yeah, and that one I'm actually going to defer and see if Guy knows the answer to that one. I don't, actually. I haven't looked at it, and I didn't have an opportunity to look at that before this session. So rather than giving the wrong answer, I'm going to skip and see if somebody else knows the answer to that.
Are you going to force me to give the wrong answer? Is that the idea?
No, I just figured you'd know.
I think the answer is that stratification doesn't trigger park dedication because park dedication is for a subdivision of land, and stratification is a subdivision of a building. That's kind of my general view.
Yeah.
Great.
I think, I mean, that's consistent with advice that I've given. You have to look at exactly what kind of stratification is happening. The bare land stratification regulation does bring in the requirement, but one of the problems is the legislation has an exemption for 4 units. You can, by bylaw, take away that exemption, but I haven't seen a lot of communities that have necessarily exercised that parkland dedication. Yeah.
Number 49, again for Alison, the town, I don't know which town, but the town recently updated the zoning and business license bylaws to regulate STRs. What supports are available, or are there any support available from the province to local governments for regulating short-term rentals in their communities?
Yeah, so I did a bit of digging around on the internet, which is always reliable, but I couldn't find any supports, and certainly the province in its Short-Term Rental Accommodation Act has sort of approached the problem from the perspective of regulating the sort of online service providers. And so I think probably what's envisioned is that the regulation of these online service providers will dovetail nicely and conveniently with some of the local regulations that tend to apply to the operators of the short-term rentals. So at the provincial level, you have them going after Airbnb or VRBO or some of the other platforms. And then at the local level, you have management of individual people who are posting their units for rent or use. Michael, I can see you look very
I'm curious whether your online research included my article in Municipal World from like April maybe last year, which was on that topic. But the province's tool, in my view, is if you can keep the properties off Vrbo and Airbnb, then you've solved the problem. And so it's going to be telling the provincial regulator they're not licensed, they're not permitted to operate here. Get them off the two big online sites.
Yeah. And no, I didn't come across your article, but I'm now curious and we'll go track it down deliberately.
Okay, on to number 44. This one's for Pam. Under the new legislation, are municipalities still able to use community amenity contributions when established in the bylaw?
Yeah, I think I've answered the question about the use of CACs. I'm not sure. I mean, the reference to when CACs are established in a bylaw is curious, because typically you have the ability, I think, to impose a community amenity contribution if it's voluntarily negotiated as part of a discretionary rezoning process. So having a CAC actually dictated by bylaw could be problematic, because that is clearly not, if it's imposed by bylaw, it's not a voluntary negotiation. So I'm not sure if that's answering the question. But I think we've kind of danced around the CAC thing in a few different ways today. I think, yes, you can still use that process, but I wouldn't recommend that you have a CAC bylaw that you impose community amenity contributions outside of. That's where you can use an amenity cost bylaw to impose amenity cost charges. If you've pre-identified amenities for which funds should be collected, then you should do that through an ACC bylaw.
Along the same lines, what is the best way for a local government to transition from their existing community amenity policy and the new ACC program? Pam?
And I think that kind of goes into looking at the considerations that local governments are supposed to review in establishing their amenity cost charges, is to really, you're looking at your housing needs reports, other policies that you have, your financial plan, and hopefully pre-identifying areas of growth where additional amenities might be required to accommodate the residents and workers that are the result of that growth. So if your OCP is transitioning an area, for example, from industrial to multifamily residential, and you've got no community centers, no parks, then you're going to need to look and pre-identify those areas and determine the amenities that will be required, and then go through the process of trying to set costs to establish the charges for them. So I think it's more of an organic process, and it'll kind of fall in line with doing your housing needs reports, updating your OCPs, updating your financial plan, and really proactively trying to identify the needs of a growing area in your community and how you're going to create sort of a supported, livable area with the type of amenities that may be required in the area. And you've got a bunch of tools that can be used, whether that's DCCs for using those now to get a new fire hall or police station in the area. And now you've got ACCs that can get you seniors, community centers, those things. So it's kind of looking at the host of tools that you have and what your needs might be. That's a long answer, but it's not, there's not sort of one way. I think it's just going to be more organic than that.
Thank you. 36 for Michael. In your interpretation, would local governments be able to set parking maximums in transit-oriented areas? We've come a long way.
Well, I'm curious as the motivation, but I view the parking specific provisions in the Local Government Act to be the required in the sense of a minimum. So if there was a maximum, it'd just be within the land use. So the permitted use of the land is multi-residential with no parking, which is an interesting use to define and to limit. And I'm not sure how that would be received by the provincial powers that be, because right now it's sort of, at least in transit-oriented areas, the market setting how much parking is provided plus the development considerations. And if you suddenly said, well, we're not allowing any parking for the purposes of, say, stifling development, then that might raise issues. But if you're saying, no, we don't want too much parking for the purposes of limiting traffic and because of the area, then if it's available, it's in just general zoning. That's my interpretation.
Okay. Number 34 for Guy, what is the process to make changes? For example, if municipalities were to adjust the height or FSR within a transit area, what will happen generally? Where should they begin?
Well, I guess it's the same process for any, assuming we're talking about height and FSR set out in a bylaw under section 479, also known as a zoning bylaw, then the way to make changes is to amend that bylaw. And the only question is whether those amendments would be offside the new section 481.01, I think the number is, that says you can't use your 479 powers to prohibit or restrict. Where is it? To prohibit or restrict a density of use or a size or dimension of a building set out in the regs in a TOA. So I guess if you were to adjust height and FSR in a manner that was offside 481.01, you'd have a problem. Otherwise, you can go ahead and use your zoning section 479 powers as you always have.
Okay. Pam, this one's for you. Number 45, can a municipality carry on with administrating their density bonus and CAC systems after 2025 if the updated expanded DCC bylaw and new DCC bylaw are not yet in place?
Yeah, and I think I've answered this as well. So this is kind of all inclusive. And I would just remind people that it's not mandatory to update your bylaws, but it is a new tool that allows you a broader scope to obtain funds in connection with development that may have cost and capital cost impacts. So while it's a useful tool to have in your toolbox, it's not mandatory, and you're not required to update your bylaws. So again, there may be a time and a place to do it as your community grows and develops, but there's no deadline or requirement to do so in 2025. And then, after that, you can continue to, or in having not updated your bylaws, you can continue your existing processes that you're currently carrying on. Yeah.
Okay. I'm looking at the clock and we've gone over by 3 minutes. I will take one more question that anyone can answer. Number 51, are there any anticipated changes to provincial housing legislation and regulations this year that you know about, that we don't know about? Have you heard anything? Nobody?
They're supposed to be rolling out a bunch of regulations that are referenced in the bills that have already been enacted. So it'll be interesting from my perspective to see with the recent election. I think there was some very aggressive policy positions taken by the province, and I don't know that they're maybe quite as confident that they have the mandate to make big sweeping changes beyond what they've already done. But politics is not the area I spend a bunch of time focused on. So, that I'm hoping not. I'll look to my colleagues who are on the call, but certainly I think it's been hard for everyone to keep up with all the changes that have already been implemented. But
yeah.
Anybody else? Any final closing comments? Okay. I'll just switch slides here. My final slide. Well, thank you to everyone. I do appreciate your time. And thank you to all our speakers, Alison Espetveidt with Lidstone and Company, Pam Jefcoat and Michael Moll with Civic Legal, and Guy Patterson with Young Anderson. Great presentation. And if you have any other questions for any of the panelists, I think they're open questions. We will provide everybody with their email contact information, and along with the link to the webinar today. I just have a few reminders again. Upcoming events, January 29th, our annual planning outlook. We have Ryan Biln with the Canadian Real Estate Association, Susan Thompson with Colliers, and Lisa Helps with BC Builds. That's January 29th. It should be a very interesting webinar. February 26th, our next PLN webinar, Housing and Infrastructure. March 26th, we have a webinar on AI in planning practice. And then April 30th, again, another PLN webinar on development economics of housing. And then, of course, June 10th to the 13th, we have the PIBC annual conference in Vancouver at the Sheraton Wall Center. I hope to see everyone there. And thank you to Young Anderson for being our key sponsor for that event this year. Okay, one more thank you to all our speakers. Your time is much appreciated, and I'll call it a webinar. Thank you very much.
Thank you.
Bye-bye.